Hello, everyone, and welcome back to the judicial process. We are in section 2, looking at the courtroom work group. So the last class we looked at prosecutors and the different types of prosecutors, how prosecutors are elected, appointed either at the federal or state level, and kind of their primary responsibilities. Today we're going to look at defense attorneys and look at the right to counsel more specifically, when it attaches, how you get it, the kind of history behind it, and then what a defense attorney really does and what their limits are in terms of limitations on how far they can go with the defense. That being said, let's jump in. So if we want to think about the establishing the right to counsel, right? The Sixth Amendment of the United States Constitution provides in relevant part, in all criminal prosecutions, the accused shall enjoy the right to have the assistance of counsel for his defense. Now, it doesn't say that the government will pay for it. It could imply that you have the right to an attorney. If you bring one, they can come, right? It doesn't necessarily suggest that you have this automatic right. That being said, at the time Bill of Rights was adopted in 1791, 12 of the 13 colonies provided for a right to counsel, right? So that being said, it wasn't until the 20th century, so until the 1900s, that this right would be fully realized. In fact, for a lot of you, it wasn't until a case came down, probably when your parents were alive, that the modern right to counsel came down. So in modern practice, indigent, which is just a word for somebody who cannot afford an attorney, so generally speaking, somebody who meets a certain poverty threshold, criminal defendants at both the state and federal level are entitled to counsel as a result of a series of cases beginning with Powell v. Alabama in 1932. Okay? So if you take a look at box 2.5.1, you see an exploration of Powell v. Alabama. Powell v. Alabama, a very important case. What you basically see in Powell v. Alabama is you have a defendant. So the defendants were charged with a variety of offenses, but basically it was Alabama in the 1930s. You had a group of young Black males who were charged with repeatedly raping one or two white females. And so there's nobody at their initial appearance, right? So when they first go to court, there's nobody there to represent them. And so the trial judge appoints every member of the bar, so every attorney in the state of Alabama, to represent them, because this was Alabama and you didn't want to be the attorney representing the people, the young African-American males who were charged with raping a white woman. Again, this is very, very racist times. So the judge thought they appointed everybody at the bar to represent the defendants, then somebody would show up. Well, trial came, nobody showed up. They had a trial. They were found guilty and sentenced to death. Ultimately, it works its way to the Supreme Court. The Supreme Court reverses the conviction and held that they were denied their right to counsel in violation of the 14th Amendment. Right. So remember, we have the Bill of Rights, and their Bill of Rights only applied to the federal government, and its application to the states only came about via the 14th Amendment. The Supreme Court, again, reversed the convictions, remanded, and held that the defendants were denied their right to counsel in violation of the 14th Amendment. The court also held that the defendants did not have the aid of counsel in any real sense from the time of their arraignment until the beginning of trial. The court noted that the defendants' illiteracy, youth, and circumstances of public hostility made it necessary, necessity of the counsel so imperative that the trial court's failure to make an effective appointment of counsel and failure to give defendants a reasonable opportunity to hear counsel was a clear denial of due process. Right, so here we have kind of special circumstances, and we're going to see that that happens quite a bit for a little while. We have illiterate we have very serious charges. We have illiterate defendants. We have youthful defendants, and we have a time of such public hostility. The outrage of this case was so great that we basically said, okay, states generally don't have to provide counsel, but in this case, when you have this kind of circumstance, then if you don't appoint counsel at the state level, you are indeed contravening the 14th Amendment. Right, so again, just as kind of a summary, now states were required to provide counsel to defendants, right? This is the first time that the Supreme Court said states ever had this duty. That being said, and in summary, the Supreme Court limited its holding. So basically, the defendant had to be charged with a capital crime. So capital crime is any crime where the sentence is death, absent of the death penalty, where there is life imprisonment without the possibility of parole, is an eligible sentence. That would be very serious. I mean, the ultimate offense. And there's the big and. The defendant was, here's a direct quote, ignorant, feeble-minded, or illiterate. Right. So basically saying, states, you don't have to appoint a attorney. It's not, you don't have any, you're not forced to change your approach unless it's a capital crime under your law and the defendant is ignorant, feeble-minded, or illiterate. And again, not the most politically correct terms by our standards today, but generally speaking, this means some kind of intellectual disability, illiteracy, unable to read or write, ignorant. That again, that doesn't necessarily just mean somebody is not academically gifted. It really does mean at that time somebody who has some kind of intellectual disability. Now, that being said, what this does is this sets the stage for Johnson v. Zerbst. Right, so this happened 6 years later. In Johnson, the court held that the federal courts must appoint counsel in criminal cases for indigent defendants. Right, so like it just does this really big departure from Powell v. Alabama. So where Powell v. Alabama is very limited, and the federal government's not going to tell the states they have to provide counsel if they don't want to, except in certain circumstances. Johnson v. Zerbst said in federal cases, right, so where we're talking about the 6th Amendment and not necessarily the 6th Amendment as applied by the 14th Amendment, that the federal courts must appoint counsel to indigent defendants. So if they're poor and they cannot afford counsel, regardless of the circumstances, regardless if it's a capital crime, regardless if it's a non-capital crime, regardless if they have an intellectual disability, regardless if they don't have an intellectual disability, if they are indigent in federal courts, you must appoint counsel. So that's 1938. That being said, just a short time thereafter, right, 4 years thereafter, the court kind of changed its course again. This time, it changed its course in Betts v. Brady. So what basically happens in Betts v. Brady is basically the defendant is charged with robbery and requests counsel. He's informed that the state generally does not appoint counsel unless it's a case of rape or murder, which were capital offenses. And ultimately he gets convicted and he requests relief. It goes up to the Supreme Court. The Supreme Court says, okay, states, you don't have to follow Johnson v. Zerbst. Johnson v. Zerbst only applies to the federal courts. States, you only have to appoint counsel if there is some kind of special circumstance that's present, right? So something that is, if not addressed, would rise to a violation of the due process of law. But beyond that, if there's no special circumstance, and we're not talking like a Powell v. Alabama type case, then you have no duty whatsoever to appoint counsel if your state legislature chooses not to follow that path. So Betts v. Brady would stand for over 20 years until an unlikely hero, and he's just one of my favorite people in history, Clarence Earl Gideon, and a liberally minded reformist United States Supreme Court bench under what was called the Warren Court would change the course of history. So, as I've mentioned before, when we talk about Supreme Courts, we call Supreme Courts by the name of the Chief Justice, right? So at the time in the 1960s, the Chief Justice was Earl Warren. And if you ever go into my office, you'll see a framed picture of Earl Warren. He's by far just, I think, one of the best jurists in American history. But he was Chief Justice during the 1960s. And this is where we see a reform in criminal justice. Now, that being said, was the Warren Court perfect? By no means. But we did see just this big extension of criminal justice rights for defendants, right, under the Warren Court. So that's the time where the Warren Court, right now, the Chief Justice is Chief Justice John Roberts. So we're in the era of the Roberts Court, right? So, and this is the Warren Court. So what happens is we get the case Gideon v. Wainwright. It's a 1963 case. Now, this is the case that you will be diving deep into in this course while you read Gideon's Trumpet, the book, which is a absolutely true story of Clarence Earl Gideon, who was an older gentleman accused of robbing a pool hall, specifically breaking a cigarette machine and taking a bunch of change out. And he gets to trial and he says, I have the right to counsel. And the judge says, no, you don't. This is Florida. Sorry. Like, no, you don't. There's no special circumstances present. And so he has to represent himself. And he actually does a fairly decent job of representing himself, but he doesn't go and pursue lines that seasoned attorneys would, right? He doesn't go down those paths. He doesn't question certain witnesses that he should. He doesn't call certain witnesses that he should, and things along those lines. So ultimately, he's convicted. He gets sentenced to prison. In prison, he writes a handwritten petition in form of a papyrus, so in the form of a pauper, meaning he doesn't have to follow all the rules of the Supreme Court. The Supreme Court required that all petitions for its certiorari be typed, they be spelled correctly, and things like that. So in you can actually see the documents today, but in his petition, right, he tries to come off intelligent, but he's very I think he has like a 4th grade, 5th grade education. And he really just spends most of his time in the law library researching the law, researching how to appeal. I mean, like, he basically teaches himself how to be a lawyer. That being said, if you read the actual appeal, it's riddled with misspellings and phrases that don't make any sense. But to him, they did. So the Warren Court, again, they can't just make a decision unilaterally, right? A case has to work its way up through the system to them, and then they can decide whether or not they hear a case. Well, the Warren Court, Warren, Chief Justice Earl Warren, wanted to revisit the right to counsel, right? He was like, this is kind of wrong. So they get this petition in. A lot of times, if it's like an informal papyrus petition, they just kind of ignore it. In this case, he takes it to the rest of the court. They have the rule of 4, which means that at least 4 justices vote in favor of hearing the case, and they decide to take on the case. Well, what's interesting is at this point, it now becomes a federal case, right? Because it's before the Supreme Court. And so the Supreme Court of the United States appoints a future, oddly enough, future justice of the Supreme Court to represent Gideon and Gideon v. Wainwright. So, and what they ultimately hold as a result of this case is that states now have to provide indigent defendants, regardless if there are special circumstances or not, the right to counsel. Basically, it was just kind of the exact same application as we see in Zerbst. So this is a monumental change, right? It doesn't happen until the 1960s. You don't get the right to an attorney at the state level, right, to, if you're poor, to a public defender, until the 1960s. So that being said, while Gideon v. Wainwright is the pinnacle case, ensuring the right to counsel at both the federal and state levels, it does not answer 2 questions, right? So it doesn't answer, when does the right to counsel begin, and when does the right to counsel end? And what we're going to see is case law develops that will answer these questions. So when we talk about the attachment of the right to counsel, a defendant has the right to counsel before the actual trial. And any proceedings that could, and this is very important, prejudice the outcome of the case against the defendant, right? So really, like, the really important pretrial proceedings. So prior to trial, you are guaranteed a lawyer during your initial appearance, your bail hearing, your preliminary hearing, your arraignment, any post-indictment interrogations, any post-indictment lineups, during plea bargaining, during the trial, if you go to trial, and then following trial, during the first direct appeal. Let's see, Douglas v. California in box 2.5.4 for kind of a nuance in this terminology of direct appeal. So indigent defense, Supreme Court also doesn't address what does it mean to be indigent, right? So if you look at box 2.5.5, the definitions of indigency vary significantly from state to state. So one state might define somebody as indigent, another state may not define them as indigent. So that's kind of a problem. And the Supreme Court really hasn't ever addressed what does indigency mean. Because at the federal level, you're generally always going to be indigent. Like, I mean, you could be a multimillionaire and still maybe qualify for the right to counsel, or qualify for a federal public defender. That's just kind of how the feds work. But the states, not entirely true. And that being said, every state provides indigent defense via different models or systems. And they fall into 3 categories. So the first category that you're probably most familiar with is the public defender system. Public defenders are overworked. They defend citizens in approximately 70% of all indigent cases nationwide. So think about this. In Florida, the average caseload for a public defender last year was over 500 felonies and 2,225 misdemeanors. So it means in a single year, they were given 500 felonies to defend and 2,225 misdemeanors to defend, excuse me. If you do the math, there's a really kind of interesting video on point that if you do the math in some cases, some attorneys could only spend, it was close to like a minute and 10 seconds on their client's case in a year, right? And so that's a problem, right? That's not, that doesn't set the stage for justice. They're also extremely underpaid. So their average salary is roughly $40,000 to $50,000 a year. And again, they're representing, 2,700 clients a year. Their average debt load is $140,616. So to put this in perspective, in Massachusetts, some courthouse custodians make more than the public defenders. In fact, when I was working at the public defender's office in Quincy, Mass, my boss had a second job at Kmart. Right? She was a checkout person at Kmart because she could not afford, between her and her husband's salary, to live. So really all of her pay went to her student loan debt, and she lived off what she could at Kmart. And that's that is an insane thing. It's a very insane miscarriage of justice, especially when you consider how many cases these people have to hear and how much of their personal time, personal lives, and personal money that it takes to deal with the current system. So the public defender system is beyond broken. It is an abomination. Other countries look at our system and can't understand how we have such a horrible, inhumane system. But it's one of the ways that we provide indigents the right to counsel. Now, do they really get a quality representation? It really just depends on the case, right? So this is part of the reason that plea bargaining happens so frequently in the system, is because there's no way that a single person can handle 2,700 cases, take them all to trial, do all that, and it's just impossible, right? So plea bargaining definitely becomes a very important part of indigent representation, and prosecutors know this, and they can't take advantage of the situation. We also have appointed counsel systems, and what happens is the appointment is made by the court of a private attorney to represent a specific indigent defendant. Right, so now they can either be mandatory or voluntary. So mandatory is basically the attorney has no choice. They have to accept the appointment unless they can show a very good reason. So for instance, like, oh, person he's charged of killing is my brother. Like, that's a good reason why you don't have to accept the appointment. But generally speaking, if you belong to the bar in this state and you get put on a list and you get assigned to people who need a lawyer. Now the problem is this doesn't necessarily mean that you're a criminal lawyer. So this is any lawyer. So this includes like lawyers who practice corporate law, or lawyers who exclusively practice probate, which is like wills, who have never seen the inside of a courtroom, nor never will see the inside of a courtroom, except to deal with this criminal case. And they can be very serious criminal charges. If you're facing a charge of murder and you're looking at the death penalty, you probably don't want somebody who practices divorce law, you probably want a criminal defense attorney. Now, when it comes to capital cases, that's a little bit different, but you get my point. They can also be voluntary. So basically, voluntary is lawyers apply or they give notice to the court that they're willing to accept indigent defendants. So in addition to their private practice, they can accept indigent defendants. And then the court uses the voluntary list to assign cases or people or indigent defendants to lawyers. Now, that being said, appointed counsel receives very, very little compensation. So if we think about how low the salary is for public defenders, appointed counsel, if you do it per capita, they make a little bit better money, but not great. There's very little incentive to take on a caseload unless you're really just interested in the ends of justice. Now, if it's a mandatory system, this annoys attorneys. Attorneys don't want to get appointed to represent people in criminal court if they're not criminal attorneys, right? So they definitely push and engage in plea bargaining, and maybe in a way that's too extensive or too forceful, then would adequately satisfy the right to counsel. And we also have contract counsel systems. So basically, there's several different types. There's a fixed fee all case. So basically, it's a law firm that says we'll handle all of the indigent criminal defense cases in this jurisdiction for X amount of dollars. Now, there could be just, this is very small. This is would never be this small, but there could be 100 cases, and they said, you know, we'll represent everybody for $5,000. Just one-time payment, $5,000 will represent everybody. So 100 cases, they get $5,000. 10,000 cases, they still only get the $5,000 because they've agreed to represent everybody, every case for a flat or fixed fee. Then you have fixed fee specific type of case. So fixed fee specific type of case, this is what we're talking about. You have a fee of $500 for this type of case, or $10,000 for this type of case, whatever it is. And so instead of just being, whether it is a low-level felony, you get $5,000, or if it's a very high-level felony, you get $5,000. Again, regardless of how many cases there are a year. Specific type of case, flat fixed fee, is, well, for this type of case, I get this much money. For this type of case, I get this much money. For this type of case, I get this much money. And it applies kind of differently. Then we have the flat fee systems. So the flat fee is literally just, it doesn't matter. You don't get paid per case. You get paid for them all. Right, so flat fee, specific number of cases. So we say for the first $1,000 or for the first 1,000 cases, you get $100 per case. Then there's a flat fee per case, right? So this is very similar to the fixed fee all cases. And this is just, you get $100 regardless of the charges. Then we have hourly fees with caps. So we can say you can, for every hour that you spend on working on this client's case, you can bill the state $30 an hour, but with a maximum of $2,000, right? And if it's like a capital case or if it's a very serious offense, the maximums are going to be increased. Then we have, very rarely, but we have hourly fee systems without caps. So that means you get paid X amount of dollars per hour, and there is no limit on the amount of money that you can make on a client. So you can see there's different ways to be invested, and our hourly fee without caps suggests that you will be doing probably more work on behalf of your client than you are going to be necessarily in a flat fee or fixed fee system, where it doesn't matter how much time you spend on a person's case, you get the same amount of money. Where hourly fee, it really does matter how much time you spend on somebody's case. So you can see even within contract counsel systems, the discrepancy in terms of even the perception of justice is very large. Now, what about the right to effective representation, right? Because that's what's required by the US Constitution. So under the American Bar Association's model rules of professional conduct. So yes, we have rules that we have to follow. I know that shocks a lot of people. People think of attorneys, we'll talk about this in a second, as like the scum of society. But we have rules, very strict rules that we have to follow. So that being said, you have to zealously assert your client's position in the adversarial system, right? You have to zealously present a defense. To this end, the lawyer owes his or her client the foremost what's called duty of competency. So take a look at Strickland v. Washington and also Missouri's constitutional crisis as to whether or not you think certain attorneys are competent, right? Is a real estate attorney really competent to hear or to deal with a felony criminal case? But you owe the utmost duty of competence. Now, compounding the rendering of ineffective assistance to counsel is the significant disparity in resources between indigent defense counsel and prosecutors. So as we looked at last class, prosecutors have very large budgets, almost in a lot of jurisdictions, almost unlimited amounts of money to spend on hearing cases and dealing with cases, things along those lines. Whereas public defenders or appointed counsel, contract counsel systems, they don't, right? They have very little money. Now they can always ask the court for more money. They can ask the court, say like, I need to hire a private investigator. And if the court finds good cause and finds that it's fits within the rules of justice, then they will allow the expenditure of funds from the state. So being said, here is really a really kind of shocking chart. So this is national spending. Since 1986 to 2008 on cases in different parts of the criminal justice system, right? So you can see that 1986, we started about $20,000 if we're talking, and this is in the millions. So like we're talking 20,000, but for our purposes, in the millions. Police have skyrocketed, right? Over $100,000 again, and that's in the millions. Corrections, we started a little bit lower. We're just under 80. Indigent defense, we started at basically 0, and now we're not even close to halfway to 20. So we're not even close to 10. So you can just see that indigent defense really has not increased, has not changed, has not had much of a difference. It's remained relatively flat. So while we increase spending on police and corrections and prosecutions, when it comes to indigent defense, we have not increased spending for the past almost 40 years. It's atrocious, is what it is. So there's always a question gets brought up about, what about pro se representation? So pro se representation is where you represent yourself. Now there is noted an English proverb that some attribute to Abraham Lincoln. He probably didn't say this, but some people attributed it to him. And the phrase is, he who represents himself has a fool for a client, right? Or sometimes it's worded another way, he represents himself as a fool for an attorney. The idea is it's really stupid to be your own attorney. Now, the reasoning behind this proverb is twofold. First, lawyers act as third parties to a dispute. So they can see the forest while the client is enveloped in the trees, right? So they are in the middle of the dispute. They can only see the trees. They can't see the bigger picture. All they can just see is just being surrounded by trees. Whereas an attorney can say, no, I see the bigger picture here. This is what's happening. You know, this is what we need to do. And they come in not scared, not hot-headed, not whatever the defendant is. Secondly, and this is most importantly, pro se defendants are expected to know the law, something that requires 3 years to learn in law school, as well as the rules of criminal procedure, something that only practice can teach, right? So in the United States, to become a lawyer, you have to have 3 years of law school after your baccalaureate degree. So it's a graduate degree, it's a professional degree, and even then, it takes practice to learn the rules and the law. And this is something that only, attorneys really get to do. But if you represent yourself pro se, you are expected to know it. Now, the United States Constitution does guarantee an individual's right to represent themselves pro se, but there are limits, right? So as you see in box 2.5.11, these limits definitely change. And so if a defendant is making a mockery of the justice system, is causing disruptions, is any kind of thing, then they can lose their right to represent themselves. That doesn't mean they don't lose the right to present a defense. It just means they have a defense attorney appointed for them at that moment. That's what they get. A lot of times when somebody decides to represent themselves pro se, we often appoint shadow attorneys, right? And so the idea is, okay, as long as you know what you're doing, and we admonish you and we tell you, like, this is a really bad idea, and you say, nope, I still want to represent myself, well, under the Constitution, we have to let you represent yourself. Well, a lot of times we appoint shadow attorneys. And what they do is they get familiar with the case and they sit in the courtroom right behind the defendant the entire case. So that way, halfway through the case, when the defendant learns, like, oh, crap, I'm doing a real bad job, or I need an attorney, they can say, Your Honor, I want an attorney. And the attorney can just the judge can just say, okay, and bring the attorney forward. And the case doesn't start over, but the attorney can start working from that part of the case moving on, right, to the end. So sometimes the defendant does too much damage to their own case. Sometimes they realize early on they don't know what they're doing. And so shadow counsel is definitely a very good system to have in place. So if we look at efficacy of pro se representation, so these are percent of federal defendants. Again, this is federal level. And this is, generally speaking, this study basically is in state court, pro se felonies defendants charged fared as well or better than represented counterparts, right? So federal defenders organization, felonies are about 30.1%, misdemeanors 25.5%, panel attorneys 36.3% versus 14.4%, private attorney 33.4% versus 18.7%. Now here's the shocker, self-representation at the federal level, 0.3% of all cases have pro se representation. Whereas misdemeanors, pro se representation hovers at 38.4%. It's actually the largest chunk of the pie in terms of representation style at the federal level. Now again, state level and state studies, at least according to one study, pro se defendants sometimes fare better than if they were represented by counsel, right? They get more favorable plea deals and things like that. That's sometimes. It's not definitely. It's definitely not the rule. It's definitely a kind of an anomaly. And when we first saw the study, all of us were like, "What?" But data is data. So that being said, I just kind of wanted to kind of round out by talking about the professional rules of conduct, right? So in 2013, Pew did a research poll, and it looked at professions that, quote, make a contribution to society, right? So it had everything from lawyers to doctors to plumbers, you name it, right? And you had to rank them on the contribution they made to society. In this poll, lawyers ranked dead last, right? And it's partially because people have a very poor perception of attorneys. I mean, they're too expensive, but there's reasons for that. It's because the tools they use are very expensive, that they will lie for their clients, and they can't. But people don't understand that, right? They see what they see on TV, or they like listening to lawyer jokes. And trust me, I love lawyer jokes because I hate lawyers. I am one, and I can't stand them. So I get it. I understand why people can see who aren't necessarily in our small club can understand why it looks shady or it seems wrong. That being said, every state has adopted some variation of the model rules of professional conduct. So to correct the profession's image, while ensuring that all lawyers are abiding by a uniform set of ethical rules for the benefit of their clients. Right, so we have very strict rules, as I said before, that we have to follow. In a criminal case, so we're talking defense attorneys, a defense attorney must serve as, and this is a direct quote from the model rules of professional conduct, they must be a zealous advocate for their client. Right? And they must counsel their client without ever repeating anything told to them in confidence. Now there is an exception. There's like an emergency exception. If your client is like, oh, I'm going to leave here, I'm going to go murder so and so, well, then you have a duty to call the police. Not tell them what your client said, but tell them that you have reason to believe that so and so is in immediate danger and that they need to dispatch the police immediately. Right. So even then, you can't reveal necessarily your client's name or that where you learned this information. I mean, it's going to be pretty obvious, but that's really the only time that you could say anything, right? Unless the client gives you permission to say anything. That being said, it's ultimately up to the client how the defense proceeds. So usually the strategy is reserved to the attorney, but it's ultimately up to the client. That being said, the lawyer must follow his or her client's instructions to the letter of their instructions. So they work for the client, regardless of the system, they work for the client up until the point it becomes perjury, right? So perjury is, I know that so-and-so is lying under oath, or that you're going to lie under oath. You've just told me your plan is to lie under oath. At that point, a lawyer can neither subordinate nor condone the perjury. So if client says they're going to lie on the stand and the lawyer says, no, you can't do that. I can't be associated with that. If you do that, I can't do it. And the client still wants to do it. The lawyer has a couple of options. One, they can try and quit the case. Now, there is a way that they can quit the case without telling the judge that they believe perjury is about to be committed, but it's called a loud exit. And what it basically does is the judge will ask, well, why do you no longer want to represent this person? You say, Your Honor, I can't tell you. And that tells the judge right away, like, they're going to try and get on the stand and lie. If they are forced to represent their client, the judge says no, then there is a way of testifying in which the lawyer can ask questions without subordinating or condoning perjury. And basically, they just get up and ask one question. In your own words, tell us what happened. That's it. Occasionally, they can jump in with like a then what, then what, then what, but they can't ask specific questions. They can't ask even very open-ended questions. They can really just ask them, like, they basically get the client to testify in the narrative. And it's gonna be really weird because in all other people that you have on the stand, And you never want your defendant on the stand, ever. But sometimes they just really want to take the stand. And if they're going to lie, you cannot do anything to further that lie. So they're going to testify in the narrative. So they're going to give a speech, basically, as to what all happened. And the jury is going to be like, okay, whoa, something's weird here. Because in all of these other witnesses, both sides have asked them questions. Like, they'd ask a question, they give an answer, they ask another question, they give an answer, back and forth. This guy's just basically reading us a speech. Something's weird here, right? And again, that's the really only way that you can get around this subordination of perjury. It's just to say, tell us in your own words what happened, and then you sit down and let the defendant read their speech at their own detriment. It never turns out well for them because they think they can always invoke the right to counsel or the right to remain silent, and they don't. They don't have any obligation to testify against themselves. However, if they choose to testify, so if they choose to give their narrative, or if they're not lying, if they choose to be honest-ish to a degree on direct examination, they can't then, upon cross-examination, so when the prosecution gets to get up and ask them questions, they can't say, oh, I invoke my right against self-incrimination. No, they gave that up the minute they took the stand. All right, so the other side always gets a chance to tear them apart. And you best believe that they are going to destroy them. They would not be at this point in the trial if they did not believe they had a strong case against the defendant. Right, and the defendant thinks they're going to be able to outsmart the prosecutor, and generally speaking, they're not going to be able to. Right, so it's just kind of a bad thing all the way around. So we zealously advocate. We hold everything in the strictest confidence. So being an attorney is really cool because really what it does is it gives you the right to hold secrets. All right, so whereas other people have to divulge secrets to the court, you don't have to. Right? There's very, very rarely, if ever, a circumstance where you get to divulge a secret. You have to take that secret to your grave. So let's say your client tells you all this stuff and then they die, and 2 or 3 years goes by and people are like, oh, so can you finally tell us, like what he said to you? No, your right to that person does not end at that person's grave. It ends at your grave. So you have to take their secrets to your grave, even if the other person is dead. It's kind of a cool thing to have, but it's also tremendous responsibility, right? And so that's why we have the rules of professional conduct that really guide everything from being very explicit via a letter to a client as to the scope of your representation, when your representation begins, when it ends, all kinds of stuff. I mean, it's very detailed in terms of the rules. And in law school, generally speaking, you have to take a course in professional responsibility, which is just another term for the legal ethics course or the rules of professional responsibility course. And before you take the bar examination, you have to pass the MPRE, which is the model professional rules conduct and etiquette, or it's basically it's the ethics test, right? And you're given scenarios and situations, and you have to say, this is what you should do ethically or what you can't do ethically, and there's minimum threshold to pass. There's the system is really trying to reform itself so that it looks like we have all these rules that we have to follow, and this has always been true, but we're trying to be more public about it to show the public, no, we're not the slime bags you think we are. We are doing the interests of justice. So that being said, the next class, we are going to take a look at judges. As always, if you have any questions, comments, or concerns, please don't hesitate to reach out to me via email, text, phone call, any way that you need to. I'll be more than happy to respond.